Constitutional law to the rescue. Is the CSA, Controlled Substances Act, unconstitutional as applied to cannabis or marijuana? Hello, I'm Morgan Davis. I'm a cannabis attorney based in Raleigh, North Carolina. Let's talk about how to keep your business protected and thriving. All right, guys, so we've talked before about how I am a statutory interpretation nerd when it comes to law. I am also a love of constitutional law. It's my favorite class in law school. And as a criminal defense attorney, which is what I did before I became a cannabis attorney, constitutional law was like the best part of an argument, right? So I am in love with this lawsuit recently filed in the federal courts by several cannabis companies that are stating that the Controlled Substances Act at the federal level, which makes marijuana illegal and creates all the problems in the cannabis space for high THC cannabis, is unconstitutional as applied to state programs. Now, you might say, well, how is that possible? Isn't the CSA, the Controlled Substances Act, allowed to regulate what is a controlled substance and what isn't? Yes, it is, when it comes to things in interstate commerce. So let's talk about interstate commerce versus intrastate commerce. Interstate commerce is anything that takes place when you leave a state. So it's all the things that are out there being sold that go over state lines. Intrastate commerce are things that are sold and in the stream of commerce within a state and do not leave those jurisdictional lines. Now, in the day and age of the internet, those lines are blurred all the time. But the law, per usual, hasn't necessarily caught up with all of us living in the 21st century. So that differentiation in where Congress's authority ends and begins still exists. This lawsuit says that the stranglehold that is still placed on the cannabis industry by the federal government through the CSA is reaching beyond interstate commerce into intrastate commerce and affecting cannabis businesses that are legitly operating under state programs. And that in doing so, it is an unconstitutional overreach of Congress's authority. They talk about examples of injury such as the fact that cannabis businesses can't use 280E in their federal tax exemption. So they end up paying way more taxes than pretty much any other business in the country. They can't get access to normal financial institutions and their various resources such as banking and payment processing because those institutions have to apply with federal law, so they can't work with cannabis businesses. Think about what the Safe Banking Act and now the Safer Banking Act has been trying to accomplish, which is essentially creating a safe harbor for financial institutions to be able to work with these businesses without fear of federal enforcement. Hasn't happened yet. So the injury continues. In addition to that, insurance, a lot of times, same issue. Insurance companies have to deal with federal regulations. And without the safety net of saying, the federal government isn't ever going to come in here and jump down our throats for working with you, we're simply not going to offer you insurance. Which is a business without insurance, that means you can't secure vehicles, real estate, employee issues. I mean, it's issue upon issue upon issue if you're a cannabis business and you don't have access to the things that regular businesses do. So you've got cannabis businesses who've paid lots and lots of money, whether it's medical or recreational, to get a license. And they are operating with very thin margins because they have to pay a ton of taxes for the reasons we just talked about. And they don't have access to traditional financial tools or insurance. Plus, they have a lot of cash on hand. See the issue we just talked about before, financial institution, ongoing. Having all that cash on hand makes them a target for criminal activity. So you see these guys getting robbed all the time and having people come in and do all sorts of craziness in their store. And local law enforcement, because maybe they don't love so much what you do or they don't understand what the role is or whatever the case may be, doesn't help all that much. So it's a huge burden to these companies that are spending a lot of money. And in addition to that, the states get taxes from these businesses. So the states are benefiting. These businesses are getting very little benefit. And the federal government is continuing to sort of keep its foot on the neck of cannabis business inside these states. While, from an enforcement perspective, the Attorney General's office, for years now, supported by several actions by Congress, has said, you legitimate cannabis businesses that have been licensed by state programs, you are no longer an enforcement priority for us. We're not spending money to come after you. We're not saying what you're doing is right or legal. We won't go that far. But we're not going to come knocking at your door unless we find that, you're doing some other crazy nefarious stuff. That doesn't always work out, but that's been the party line now for quite a while. And yet, they won't take their foot off the neck of cannabis business. And so this lawsuit says, guess what? You've already admitted that we're not an enforcement priority. You've already opened the door a little bit. It's time for you to open the door the rest of the way. And the fact that you aren't doing that and you're continuing to affect these businesses, even though they're not in interstate commerce, they are only in intrastate commerce. You, Congress, through the CSA, are overreaching your authority. And the ask of the judge, who will ultimately decide whatever they're going to decide in this case, is that they do two things. One, they issue a declaratory judgment saying that the CSA is unconstitutional as applied to the manufacturing, distribution, and sale of cannabis in intrastate commerce. That's a big deal. It's the difference between, it's having the federal government say, not just, you're not a priority for us, we're not coming after you. It's having the federal government say, we can't come after you. Doing so would be unconstitutional. It's a very different level of protection for state programs than exists right now. And the second thing they're asking for is basically for them to prevent the CSA from being applied in the future. No matter what happens with this case, it's going to be very interesting for everybody involved. We'll be watching closely. Stay tuned, and we'll have an update for you hopefully in about 180 days.